Welcome to Subramani. You can see I'm on a vacation, and yes, I'm at Ranthambore. Uh, I have to make videos which I don't have much assist. So one of the videos which I always thought of making but never made was that should you make a will with just your lawyer or like the Americans say attorney? And the answer is no, because there are certain things which your attorney does not know or your lawyer does not know, and your lawyer does not spend as much time with you as your financial planner. For example, if somebody were to come to me and say, make my will or make my estate planning document, first of all, I would start by asking, is your name in the PAN card, in the Aadhaar card, and in the passport, and in the bank account the same? First, get all this in sync, because otherwise it can create a lot of problem, and it can be Viswanath, Visvanath, Hwanath, some spelling mistake somewhere, and it can hurt your hairs really bad. So I would first put all that in place. Then I would ask, what are your intentions? Please discuss with your family, have it in writing, and then let's start. So many people, for example, when I went to make my will, my lawyer did not even ask, I wouldn't call him my lawyer, the lawyer who made my will, did not even ask whether my parents were alive and whether some part of my money should go to my parents. He did not ask. My mother is alive. It is possible that she was dependent on me. It is possible that I was sponsoring some aunt or uncle or my history teacher or somebody, right? No questions asked. He just said, oh, whom do you want to make a will for? You and your wife, okay? And who is going to be the beneficiary? Your daughter, okay? Your daughter is a major? Yes. That was when I was revising my will. Earlier she was a minor, so I was revising my will. That's all, no questions asked. Now, I could have had a dependent parent, dependent sibling, dependent anybody, right? Dependent charity, anybody could be there. So nothing was included. So first step is get your name in order. Also understand that estate planning is about protecting your loved ones and preserving values and legacy, right? But I think 50% of Americans don't have a plan, and I think the figure could be 70% for Indians. So the question is, when should you make a will? You should make a will the day you buy property, because your mutual funds and all that under normal circumstances will go to the nominee. Of course, somebody can challenge and say the nominee is not correct, or I'm the son, friend should not be the nominee. Fights are possible. Ideally, it should be mentioned in the will, but it is not a killer if it is not mentioned in the will. I'm not saying don't mention. Whatever your attorney says, whatever your lawyer says, do that, but take your financial planner along. Make sure that every asset is included if you are going to include. There are people who say just include the real estate, the other assets will follow, jewelry will follow, don't write about the jewelry. I'm not getting into the legal part of how to make a will. I'm just saying where your financial guidance can be useful, and you should have your financial planner along. So first of all, get all your documents in place, because when he makes a estate plan, he will want to mention the geography of the real estate that you have, that this is a freehold land, this is a leasehold land, whatever, all that. So estate attorneys or lawyers are experts in the legal process, but they work from a small snapshot in time. They come and meet you for half an hour and the whole thing is done, whereas the financial planner has been with you for 5, 10, 15, 20 years, whatever. So the financial planner has a completely different vantage point. He knows your family completely. He can he's come with you through your life transitions. He knows you may want to include your nephew or niece in this, because your brother or sister may not have enough money to pay for their education, so you may want to include all that. So all these discussions you have either in the presence of the attorney or separately, but you make down, distill it, and then you make your will. Understand, your financial planner presumably understands your goals on a deeper level than your attorney can, because your attorney is going to spend half an hour, 1 hour with you. Your financial planner is spending decades with you. That's a big difference, right? So together with your attorney, it can work and work well. And when I'm talking of estate planning documents, I don't mean only the last will and testament. Yes, this is the most important thing. You need your will, but understand your will comes into play only after your death? What when you're alive and you can't sign checks? Then what happens? You're in coma, then what happens? You need a financial power of attorney. Somebody should have a financial power of attorney, especially if you're a single name. Now, if I have joint account with my wife, or an either or survivor with my wife, if I'm dying, if I'm dead, if I'm in coma, it won't matter. My wife will be able to access the account. Yes, she'll be able to do a forgot password kind of a thing, go and change the password, whatever, but she can still handle it, right? So you need a financial power of attorney, you need a healthcare power of attorney, which designates someone to make medical decisions on your behalf and say, okay, I want this treatment, I don't want this treatment, this is the money that has to be spent and this is how it will be spent. So somebody with a healthcare power of attorney. Trust. Does everyone need a trust? Well, everyone does not need a trust, but if you need a trust, look at a trust, because to me a trust is very useful. If you have a son and you're afraid that the son's wife, your daughter-in-law, will sue for divorce and take away half the property. Prenups don't work much in India. You can still make a prenup because the girl may not know that it doesn't work. If it is outside of your community marriage, then under the Special Marriage Act, your son might still get protected. But otherwise, a lot of money will be lost in litigation, and the shrew can take away half your money, wealth, right? So if it is 10 crores, 20 crores at stake and you don't want your son to have that risk, a trust makes sense. But I would just leave it to you. Not everyone needs a trust. A trust is expensive, so think about it. You can, one more place where it helps is you can delay giving the money to your children. You can give a portion of it at 18, some portion at 25, some portion at 35, and everything at 45. So something like that you can do with a trust. So think about it. And make sure that the beneficiary designations are right. This your financial planner should be able to do, because he'll be able to tell you, look, you had this divorce, have you changed the designation in your provident fund, in your PPF, etc. So sometimes you have to change the designation. So have you done all that? Then so sitting with your financial planner has all that uses. So avoid the, after this you still will make some common mistakes, but you can avoid them by you have to understand that could be a big gap between what you have spoken to your advocate or your attorney and what finally appears, and you may not be able to understand that. So it's better to put two brains, get it done and get it checked internally by you, your wife, your husband, whoever, and children. If your child, I mean, if you're 60 years of age, it's possible that your son or daughter is a lawyer, right? So somebody like that to also check it. A financial planner is trained to note these nuances, right? Something which a financial document may not address. Some may just fall short in real life. For example, families tend to, I mean, if you decide to divide your assets equally between your son and your daughter, and your son gets, let's say your son gets a flat, but he is an NRI, so he will have to sell it, right? So that may not be the intention. So sit and talk to your children. I know cases where the NRI children have said, I don't want anything in India, give everything to my sibling, but there are people who have fought for it also, right? So all these kind of things will happen. So find out what is good for you. Make sure that the small details don't fall through the crack, because you will have a big document which you may not understand. You think you've spoken very clearly, but it may not be very clear in the written document, right? So it may be difficult, and also on the death of a person, this may be difficult to sit and think and talk about it. So review your plan every 5-7 years or 10 years. Change of beneficiary may be necessary. You were young when you made it, you included your mother is no longer there, so you may have to include your father. You may have to change the nomination from mother to father. You may have to do those things. You got married, you had one child, you made it, now you have two children, both children have become major, you need it, right? So when children attain majority, or when your spouse dies, you're married again, or a divorce and married again there would be changes in the will. So while financial planners are not exactly advocates or attorneys, they know these events. When they see an event happening, they know what should be the trigger for remaking the will or rewriting the will, or you sold off one asset, you bought another asset. So some of this may have to be incorporated in the codicil. So check for all that. Whether you are building whether you're building your estate plan from scratch or reviewing what you have, a financial planner or a financial advisor can surely help. So sit with the person, and it's not going to be very expensive. Pay him a small fee, but get it done, get it reviewed, so that you know what you're doing and he also understands your real intentions. Thank you.